welcome to Legal Lines. My name is Tim Lynch and I'm your host of Legal Lines. Legal Lines is brought to you by the Massachusetts LGBTQ Bar Association. We're brought to you live the third Wednesday of every month. My guest here today is Jansen Wu. He is an attorney with the wonderful organization of GLAAD, and he was recognized recently by the American Constitution Society, and we're always happy when one of our fearless leaders, fearless fighters is recognized for his good work. And he was awarded the Carl Liner Award, so he's going to tell us a little bit about that and a little bit about what's going on at GLAAD these days. Jansen, how are you?
Good, how are you? Thank you so much for having me on the show.
My pleasure. Why don't we start off by, just saying exactly what GLAAD is, remind our viewers what GLAAD is and what GLAAD does.
Sure. So GLAAD is Gay and Lesbian Advocates and Defenders. We're a legal organization based here in Boston. We work in all 6 New England states. And we advocate for the rights of LGBT people and people living with HIV. So that means bringing lawsuits when there's a legal matter at hand. It means working in our state legislators to try to get good bills passed. And it also means doing public education as well, too, so that people in the larger public understand the variety of issues and challenges facing the LGBT community.
And you do a lot of that education through litigation as well. Whenever you have a case, you try to educate the public through the case, which I think is a wonderful way to do it.
Yeah, so I think actually one of our best known cases, the Goodrich case, is one of the best examples of that public education through litigation. So GLAAD brought the lawsuit that brought equal marriage rights to gay and lesbian couples in Massachusetts, and we also used that lawsuit as an opportunity to teach, educate, and show the public what the reality of LGBT families are, which is just loving and committed couples trying to do the best they can and raise their children right.
Yeah, they're just as normal as everybody else, and unfortunately have the same problems that everybody else does.
Yeah, we're no different, no better, no worse.
And always God bless the people who are the plaintiffs in those cases, because they certainly hold their lives open to public scrutiny. So to me, they're always the unsung heroes in all these cases.
They are. I mean, they're absolute inspirations for being out there and putting their lives out there to try to advance the community as a whole.
So let's get to you now. You've been with GLAAD for how long?
Just a little over 6 years.
And your work was recently recognized by I have that right? The American Constitution Society. Tell us a little bit about the award you received.
Well, I was really excited. The American Constitution Society is one of the leading organizations at the forefront of a progressive interpretation of our country's Constitution. And they, 4 years ago, created this award along with the Carliner family to recognize the memory of David Carliner. And David Carliner, I'd done some research on him in preparation for this award. I also met with his family before I received the award. But he was really an extraordinary individual who was on the forefront of civil rights back in the 50s, 60s, and 70s. He actually litigated one of the very first gay rights cases in our country on behalf of a federal employee who was fired for being gay. He litigated one of the predecessors to the Loving versus Virginia lawsuit, which is the U.S. Supreme Court case that said that states could not prohibit different race couples from marrying. He had actually brought a previous case to the Supreme Court on those same issues. So in many ways, he was a real champion, really on the forefront, and I was really honored to be recognizing his memory through this award.
Well, that's great. It's wonderful when a family does something like that, because obviously this is a person that does deserve to be recognized for all of his work. But you were recognized. For what particular work have you done?
Well, the award was for mid-level public interest attorneys, which is really great that the family and ACS wanted to recognize this, I guess, part of your career, because there aren't a lot of awards kind of recognizing lawyers who are kind of in the middle of their career. And thus far at GLAAD, I've been very lucky to have a wonderful job and work at a wonderful organization where I've been able to achieve some good change. I most prominently am part of the legal team that is bringing the challenge to the Defense of Marriage Act. That's the case Gill versus OPM. And we recently just got a terrific opinion out of the First Circuit Court of Appeals, which is the middle court of appeals, agreeing with us that DOMA, which basically says that even if you're married in Massachusetts, the federal government will pretend that you're not married. And that means for purpose of your federal taxes or your Social Security benefits or family medical leave, the federal government is going to treat you as single even though you're married. And so what the First Circuit Court of Appeal said, in their opinion, in their ruling, was that this law was unconstitutional. And so that case actually is going up to the U.S. Supreme Court, or will likely go up to the U.S. Supreme Court in the next term, and we're really excited about that.
Well, let me take you up on that. So it's the DOMA law, Defense of Marriage Act, as you say, and you litigated the case before Judge Toro here in Massachusetts, and he granted summary judgment on that, ruling it was unconstitutional. And the issue is a very defined legal issue. It's not the whole act, but it's the act that says the federal government can't discriminate between different marriages. Not that gay people can't marry. The state's already determined they can marry. It's the just unique legal issue is can the federal government discriminate against different marriages?
That's exactly right. So this case isn't about whether or not a state has to allow a couple to marry, let's say Texas. It won't affect any other state with regards to their marriage laws. But what it does say is that if your state does decide to let gay couples marry, like Massachusetts has, the federal government has to go back to the rule that it's always had for the entire history of this country, which is just to defer to the state's determination of who is and is not married. So for 200 years, the federal government just said, all right, if you're married at the state level, you're married at the federal level. Yeah. And they never questioned that until 1996 when Congress passed and President Clinton signed the Defense of Marriage Act. And that really was the first time ever that the federal government refused to recognize only one category of marriages.
Yeah, and I think the point is well taken as well, because you mentioned Loving v. Virginia, interracial marriages. And even after when some states were allowing interracial marriages and other states weren't allowing, the federal government recognized marriages, whether they were interracial or not. It's just when this issue comes up that we have this DOMA Act, which is unusual.
It's particularly unusual when you look at the history of diversity in our country around marriage law. So throughout the entire history of marriage in this country, states have always had different rules about who can and cannot marry. So, rules depending on how old you were, or whether you were first or second cousins, or whether you can marry after divorce, or whether interracial couples can marry. And despite all this variety at the state level, the federal government has never gotten involved before, except for the very first time when gay couples started marrying. And so it really is an exception that was created for gay couples only, and which uniquely harms gay couples.
Yeah, and here's another case where you had interesting plaintiffs who actually showed how they were harmed. So maybe you can go through that for us, because many of them are very interesting.
Absolutely. I mean, again, this is another wonderful example of how we can use litigation to educate the public about the reality of gay lives and the harms that they suffer, unfortunately, sometimes. So one of our plaintiffs, Herb Burtis, he's 82 years old now. He had been with his partner and husband, John Ferris, for 60 years. And in the last 6 years of John's life, he took care of John while he was dying of Parkinson's. And after John passed away, during the most difficult period of Herb's life, at least, he went to the Social Security office, to ask for the same protections and safety net that every other married couple receives, which are the survivor benefits that you receive from Social Security when your spouse dies. And very sadly, at the front desk, the clerk said, "Sorry, we don't recognize your marriage and your relationship of 60 years. And what does that mean concretely? It means that Herb Burtis is being denied $700 a month, and that's the same cost as his medication, basically. And so it's a real harm for somebody who's on a fixed income, an elder person. Another one of our plaintiffs, Nancy Gill, is a postal worker. And she normally, if she were in a straight married couple, she'd be able to provide health insurance benefits to her spouse. But because her spouse, Marcel, is a woman, the federal government refuses to provide those same health benefits. And what that has meant is that Marcel had to continue working in order to get those health insurance benefits, as opposed to be able to stay at home and take care of the kids and be a stay-at-home parent, which is what they would prefer to do.
Isn't one of them like a veteran and they can't be buried together?
There's actually two cases. One of the cases is our case, the Gill case, where we have 7 plaintiff couples and 3 surviving spouses. And then there's a second case actually that the Massachusetts Attorney General's office brought as well too. And they brought claims that are very much based on the state's rights and prerogative to determine who is and is not married in Massachusetts. And one of the examples that they pointed to was actually with regards to veteran cemeteries. So the federal government will provide grants to the states to create and maintain veteran cemeteries for veterans to be buried in. And under the normal rules, a veteran can be buried side by side with his spouse. Unless, of course, you're a gay married couple, in which case they can't recognize your marriage and they won't allow you to be buried next to each other. And Massachusetts actually received an application from a veteran who wanted to be buried next to his spouse, and because of the Defense of Marriage Act, had to say, sorry, but our hands are tied because of the federal government is forcing us to discriminate against you. And that's really the basis of the Attorney General's suit.
Yeah, so you can fight for the country and, and you have these issues. The other interesting part of it was you won in the district court, then goes up to the Court of Appeals, and it was a unanimous decision.
That's right.
Yeah, and so now there was a change while the case was pending. First, the Obama administration, the Justice Department was defending the action, and then they switched. Well, could you tell us a little bit about that?
Sure. I mean, it's been a little bit of a roller coaster in terms of litigation. We started off suing the Office of Personnel Management, which is part of the Obama administration, and the Department of Justice was defending the constitutionality of DOMA. But at some point, when you really look at it, it really is an indefensible law. There is really no way to justify the discrimination on a legal basis and also as a matter of fairness. And so the Obama administration looked at the law and they decided, look, we can't justify defending this law anymore that's so clearly constitutional. The analysis was a little more complicated. Basically what they said, the Obama administration did, is they said that gay and lesbian individuals deserve what's called heightened scrutiny. And in constitutional law, what that means is that you have to be particularly suspicious of any laws that discriminate against somebody based upon their sexual orientation because of a history of discrimination against that group of people, or because it has it's not related to a person's ability to contribute to society at all. There's no good reason for the laws, and so when you do have laws that discriminate based upon sexual orientation, then you got to look at those pretty carefully. That's the way we treat laws that discriminate based on race, that discriminate based on national origin, and religion, and on sex. We haven't had any courts yet, or we haven't had the Supreme Court yet, at least, weigh in as to whether or not gay and lesbian people deserve this type of heightened scrutiny protections, right? And what the Obama administration did is said, they looked at it, they looked at the law, and they looked at the facts, and they said, you know what? Gay and lesbian people should receive those same type of constitutional protections that categories based upon race or sex receive as well too. And under that heightened level of review, there's no way we can defend this law.
No, under the Equal Protection Clause.
That's right, which basically says you should treat people the same who are the same, and that's what we're asking for here.
Yeah, it's a simple, basic truth about equality. You treat similarly situated people the same. I mean, that's the hallmark of American constitutional law.
And especially in the situation of DOMA, because in DOMA, the couples are already married. Yeah. It's not as if Congress can prevent Massachusetts from allowing gay people to marry, right? So it's not even that the federal government is distinguishing between gay people and straight people. They are basically treating differently one class of individuals who are all married and splitting them in half based upon whether they're gay or straight.
You've been watching Legal Lines. Legal Lines is brought to you live the third Wednesday of every month. My name is Tim Lynch. I'm your host of Legal Lines. If you'd like to participate in our program, and I invite you to do so, our number here is 617-708-3290. Again, 617-708-3290. Why don't we talk about that issue of scrutiny, because it's, just for our audiences, these are called equal protection cases, which basically you mean you treat similarly situated people the same. And when the courts look at a law to see if it violates that principle, it looks at it through 3 different levels, whether, heightened scrutiny, minimal scrutiny, and then there's an in-between standard.
Yeah.
And I guess the Obama administration, you say, wants to use the heightened scrutiny. We have no guidance from the Supreme Court as to what level of scrutiny you apply to gay couples at this point.
That's right.
So, but even under the minimal standard, there has to be some rational basis for this law, and I take it the courts have not been impressed with any basis put forward.
It's very hard, I think, even to pass rational basis tests. So the rational basis test is really the most deferential standard that the courts apply to an act of Congress or legislature. And it basically says it just has to be rationally related. You just have to have some reason. It doesn't have to be a good reason, but you have to have some reason for discriminating against a group of people based upon their sexual orientation or based upon another characteristic. And what reasons are there for DOMA when you have a history of the federal government always treating marriages as valid if they were validly entered into at the state level, except now because of their sexual orientation. And now, so Obama administration is no longer defending DOMA, and so the House of Representatives, and more specifically the Republican leadership of the House of Representatives, have intervened in the case, and now they're effectively defending the constitutionality of DOMA, and they came up with a few reasons, which if you really look at them closely, just have nothing to do with DOMA whatsoever, right? So some of the reasons they've given, if you look back at what the justifications were in 1996 when they passed the law, one of those justifications was to maintain traditional marriage, right? Yeah. Well, again, gay couples are already getting married in Massachusetts, and the federal government is simply refusing to recognize those marriages, but can't do anything to prevent those marriages, right? So how is that at all rationally related to wanting to maintain traditional marriage, even if that in and of itself was sufficient or a legitimate reason, which we would say it's not a legitimate reason. What is maintaining traditional marriage other than just another way to say we don't want gay couples to marry, right? There have been explanations or justifications based upon child rearing or whether or not gay people make good parents or not. But again, if you look at it, gay parents are already becoming parents in Massachusetts and many other states, even in states where there isn't marriage, but gay couples are allowed to jointly adopt children, right? So what does the Defense of Marriage Act and the federal government's non-recognition of marriage has anything to do with promoting this ideal that they have of child rearing? If anything, all it does is hurt children, because we know that these protections and these safety nets that the federal government provides for married couples are also to protect the children as well, too.
Yeah, the children of the couples need the protection. And not only that, but I do a lot of work with abused children in the court system, and it's amazing how many foster children we have out there. And it's not a zero-sum game. It's when you have more couples who can adopt children, it's a wonderful thing. I was reading a statistic that 75,000 children were adopted out of foster care by gay and lesbian couples since they started allowing same-sex marriage. I mean, those are 75,000 people who have a steady, permanent home. And the comparison, I think, is not between, different marriages. The comparison is between growing up in foster care, where you move from home to home to home, to moving to a home where it's a permanent home, where you have 2 parents who take care of you. So there's so much good that comes out of this to society. It's amazing how people are still arguing against us on these issues.
That's absolutely right, and it always infuriates me when I see the other side take up this mantle of being pro-family, quote-unquote, right? Well, I think being pro-family means supporting and protecting all families, and particularly the children of all those families. And that's what we need to do by dismantling DOMA.
So where are we now? You won the First Circuit. As I understand it, there is occasionally an en banc hearing where the whole court hears it, but 3 judges unanimously decide, and there's only 5 judges in the First Circuit. So the issue now is, do they appeal to the Supreme Court? So where does that stand?
That's right. So the House of Representatives, specifically the Bipartisan Legal Advisory Group, or what we've been calling BLAG, which is the leadership group that's controlled by the Republicans, they have asked the U.S. Supreme Court to review this case. the Department of Justice, even though they're no longer defending DOMA, has also asked the U.S. Supreme Court to review this case because it's a matter of national importance. You know, it's very unusual for a court to actually strike down a federal law, and so we really do need national clarity on this question. So it seems very likely that the U.S. Supreme Court will consider the constitutionality of DOMA in the next term, which runs from October of this year till June of next year. So basically, by June 2013, we'll have an answer, and we're very excited to, be part of that process.
And as of now, there's only one circuit court opinion, so that governs the First Circuit, which is basically New England, as I understand it. And if it goes to the Supreme Court, and the Supreme Court rules as we think they should rule, then it covers the country.
It will affect the entire country, married couples across the country. So it will be a big deal, and we're definitely hoping for a victory. But before then, there's a lot of hard work to be done before then.
So you've also done work in other cases. You've done a wonderful work, as I understand it, for transgender rights in Maine. Why don't you tell us a little bit about that?
Sure. So Maine is one of the few states that actually protects transgender individuals from discrimination, and that includes discrimination in employment and in public accommodations like the restaurants and businesses that you go to on a daily basis, in education, and in housing. And I just want to emphasize that this really is the minority of the country. In the majority of the country, it is still legal to fire somebody, to kick them out of a restaurant, to evict them because they're transgender, and also because they're gay or lesbian. And so this is why these laws are so important. And Congress could fix it in one fell sweep by passing the Employment Non-Discrimination Act and adding protections for sexual orientation and gender identity at the national level. But for now, what we're dealing with is a patchwork of state protections. So Maine is one of those states that actually protects transgender individuals in public accommodations. And our client, Brianna Freeman, is a transgender woman who had been a regular at Denny's restaurant up in Auburn, Maine. Until Denny's restaurant received a complaint from a customer and told her, sorry, but you can't use the women's restroom anymore. And this is our client, a woman who's been living as a woman for many years, and there hasn't been any other problems up until this point. And basically, there's no option for her to use a men's room, right? Because she is living as a woman and appears as a woman, and it'd be very dangerous for her to use the men's room. And now Denny's restaurant is also saying you can't use the women's room as well. So basically, they have said you can't use the restroom at all in this restaurant. And this may sound like a small issue, but it actually is a huge issue for transgender people across the country, which is just access to safe and appropriate restrooms. It's a public health issue. You basically can't participate in society. You can't hold down a job. You can't go out in public if you can't use a restroom. And that's unfortunately the situation that so many transgender people face. So we sued Denny's restaurant under the anti-discrimination law. And we had a hearing in front of the court, and we argued that the law prohibits Denny's restaurant from refusing to allow a transgender woman to use a woman's restroom. We must have argued it so well that Denny's settled 2 weeks later. So we actually got a great settlement where she's allowed to use the woman's restroom. Probably the most interesting part of the settlement is that she got 2 free meals a day at Denny's restaurant for the next year.
Oh, that's wonderful. Good for her.
And she was a regular, So unfortunately, whenever you bring these cases, there's always the risk of a backlash. And we did see that backlash happen in Maine, where one of the state representatives, Ken Fredette, brought a bill to try to exclude restrooms from the anti-discrimination protections in Maine. And so this bill would ultimately force transgender individuals to have to use the restrooms that match the sex that they were assigned at birth, as opposed to the sex that they're actually living now. And that would have been really incredibly devastating. And so I'm glad, along with a coalition of organizations and individuals in Maine, fought really hard and were able to defeat that bill, which was really a huge victory for us because the legislature at that point was a little bit more conservative than it had been in the past. But we were really able to kind of convey to the legislators, look, not only is this devastating to a very vulnerable group of community, which already suffers so much discrimination and harassment because of who they are. But it's also impossible for businesses to enforce. I mean, what is a business supposed to do? Play bathroom police with every single person who wants to walk in?
What are they supposed to do?
I mean, and how are they supposed to administer that? How are they supposed to, even determine who can use which restrooms? And so we were able to convince the legislature that this would just be a total disaster, and they ultimately defeated that bill. So we were really excited about that as well.
It's not only decide what is a restaurant supposed to do. I mean, how do they determine the biology of their customers? The other side of it is that, not only can you not enforce it, but how they treat their customers to begin with. Of course, they want goodwill. They want people to come in and use their facilities. And good for Denny's. I think that's a wonderful thing they did.
Yeah, and we're really excited that Massachusetts is now joining those states where transgender people are protected from discrimination, except that the state legislature didn't include public accommodations protections, which includes the restaurant situation that we had in Maine. So we really hope that Massachusetts will very soon fix that problem and include protections in all areas.
Yeah, and the thing I meant to mention earlier was there's never been a case where somebody using a transgender person using a restroom has caused a problem, a criminal problem. And as I understand it, even Suffolk County DA, Dan Connolly's come out and said, we've never had a case like that. So this notion that something's going to go wrong or go awry is just there's no evidence of it.
It's really a scare tactic that from people opposed to extending civil rights and protections that really distracts from the ultimate question, which is I think that we should protect all individuals, protect their dignity, protect their humanity, and allow them to be able to live up to their fullest potential in society.
Yeah. Well, thank you very much, Chance. Thank you for the wonderful work you do.
Thank you.
And do unto others as you would have others do unto you. I think we can end on that note. Thank you very much for watching Legal Lines. My name is Tim Lynch. I'm your host on Legal Lines, and we're brought to you by the Massachusetts LGBTQ Bar Association. Tune in next month, August, third Wednesday, which I think is the 18th, for our next episode of Legal Lines. Thank you again.